Good morning. Welcome to, I guess this is the second today of the Reinhardt CLE series. This entitled Impact of Yates on Attorney-Client Privilege and Corporate Compliance. Thank you to all the folks in the room here and to all of you tuned in via the web. Appreciate you attending this morning. I'm Ryan Stivic. I'm a shareholder in the litigation department here at Reinhardt, and the focus of my practice is white-collar litigation and compliance, and in particular securities litigation and financial fraud type internal investigations. And I'll be presenting on this topic here today with my colleague Heather Fields. And we'll kind of be switching off back and forth, and Heather will give you a little more detail on her background when she comes up here in a few minutes. Just a couple housekeeping items. You've got these in your materials, and the one thing I just wanted to highlight was to you out over the web, to the extent you have any questions. Go ahead and type them into the questions section on your webinar panel, and we will try to get to those at the end of the presentation. So what are we going to talk about today? We're going to talk about, of course, the Yates Memo and put it in the context of the Department of Justice's prior memos that have been issued over some time. We're going to talk about the impact of the Yates Memo for compliance programs and internal investigations, and the impact on privilege and work product issues in conducting internal investigations. And then we're going to conclude with some post-Yates kind of readiness tips and things that you as in-house or outside counsel should be thinking about as we move forward in light of the Yates Memo. So what is the Yates Memo? It is Sally Quinlan Yates is a Deputy Attorney General in the Department of Justice, and wrote this memo to all DOJ attorneys. So it went to all civil attorneys in the Department of Justice, all criminal attorneys, and all attorneys in every division, so antitrust, environmental, tax, etc., which is a little bit different than some of the memos historically that went, for example, only to the AUSAs that prosecuted criminal cases and such. The corporation, representing a corporation, as you'll hear a little bit later, is different. Of course, a corporation can only act through its constituents, through its executives and employees. But yet a corporation can't go to jail, only the people can. And so this has always raised difficult tensions when allegations of corporate wrongdoing arise, either through whistleblowers or government investigations, or learning of wrongdoing through just the regular compliance activities. And due to those thorny issues with corporate liability, where particularly during the investigative phase of a government investigation, there's a natural inclination on the corporation's part to settle those claims by paying money, as opposed to long, drawn-out, protracted litigation. But of course, that tension arises with settling those claims, implicates the personal liability and the conduct of those executives and employees that were involved in the wrongdoing. And due to those thorny issues of corporate liability and the tension of the interests of the corporate person on the one hand, and the personal interests of the people that run it and may have been involved in the alleged wrongdoing, the Department of Justice has periodically issued these types of memorandums, dating back to 1999 with the Eric Holder memo, when Mr. Holder was a Deputy Attorney General at the time. That memo was titled Bringing Criminal Charges Against a Corporation, and talked about certain principles that the Department of Justice should look at when doing so. And throughout the years, there's been the Thompson memo in 2003, the McNulty memo in 2006, the Phillip memo in 2008 was the last one, and they all get known as after the person, the Deputy Attorney General that wrote them. And so now, September 9th, 2015, we have the Yates Memo, which is actually titled, the subject of the memo is Individual Accountability for Corporate Wrongdoing. And it's meant to highlight that the Department of Justice wants to focus on individuals who perpetrate corporate wrongdoings, and that those individuals should be personally accountable. There's some belief that this is reaction in some way to concern that coming out of the financial crisis in 2008 and 2009, that very few of the top executives at the large banks like Bear Stearns and JP Morgan and things like that did not face personal liability or criminal liability as a result of that. And so the Yates Memo focuses on kind of identifying best practices that have already been occurring within the Department of Justice and sending those out to every attorney to focus on those issues. And so it instructs Department of Justice attorneys not to give corporations credit for cooperation with the government when it comes to resolving the case, resolving the allegations of wrongdoing, or reaching plea deals with corporations, unless the corporation identifies all personnel responsible for the corporate actions under investigation, regardless of position, status, or seniority, and produces all facts relating to the alleged misconduct. And it's this all facts related to the alleged misconduct, which is a bar over which you must you must get in order to receive any cooperation credit. That approach, this all or nothing approach, is a relatively significant change over the past DOJ practice, including that outlined under the Phillip Memo, where disclosure of the facts was one factor amongst several factors in determining whether the department should grant a cooperation credit to the corporation in reaching plea agreements or settlements with the corporation. Other aspects of the Yates Memo. Ms. Yates instructed DOJ attorneys that no resolution of corporate liability should be reached without a clear plan to resolve or pursue individual cases. And that applies to both civil or criminal cases, civil or criminal liability. And moreover, when resolving a case against the corporation, DOJ attorneys are now instructed that there should be no releases for individuals from civil or criminal liability absent extraordinary circumstances. So as outside counsel, when I'm representing a corporation in these types of matters, one of the things you want is a global settlement of all liability for the company, for the executives, for anybody involved, so that once you reach an agreement on corporate liability, you're not going to have these follow-on cases against the executives where that kind of that finality and kind of putting the episode behind the corporation is not achieved, because inevitably you have to deal with that litigation against the individuals and oftentimes paying for their defense, so it doesn't really cut off those types of expenses. Well, now this essentially says that the DOJ is not going to enter into a global release of the individuals absent extraordinary circumstances. And if a lower level attorney in the DOJ wants to reach that type of settlement based on extraordinary circumstances, they have to get approval from an assistant attorney general or by the U.S. attorney, the top attorney in their district, in order to reach that type of settlement. And then finally, the Yates Memo brings the notion of the criminal notion of deterrence into decisions about pursuing cases against individuals civilly. So in the past, typically, the DOJ would look at the primary factor is whether the individual would have the ability to pay any sort of fine or judgment that might be imposed as part of the civil case being brought against that person. The Yates Memo says, well, that shouldn't be the determining factor. We should look more broadly because even civil cases can have a deterrent effect and help deter future corporate wrongdoing because of the penalties, fines, judgments that can be imposed, even if the person does not have the ability to pay. So with that, I'm going to turn it over to Heather to talk about compliance, how Yates starts to affect compliance investigation.
Good morning. Thanks for having me this morning. I am pleased to be talking about this because it's something that Ryan and I have been talking about since it first came out. And for those of you who haven't read the memo, it's short. I recommend that you do. It really seems simple on its face. But I'm hopeful after this you'll be a little bit more sensitive to some of the really serious implications. So in terms of Yates and its impact on the role of general counsel, I know many of you either on the phone or here today are working in-house. I think that Yates has made things particularly complicated for general counsels, and I would say that for a couple of reasons. First of all, I think that's because in order to be an effective general counsel, you need to engender the trust of the folks you're advising, your client. And although your client is technically the organization, and I'll talk about the challenge of that in a moment, you work with a group of executives and employees and board members and people who really need to feel like they can approach you, come to you with concerns, questions, problems. And I think Yates really complicates that because to the extent that the general counsel now really has to be very clear on the organization as the client versus any of the individuals that they work with day to day, I think it's going to be very challenging to, particularly in highly regulated industries, for everyone to keep their hats straight and for counsel to be as effective as they have been in the past. I think really the key, the most granular level, the key challenge is how are you going to conduct internal investigations after Yates in a manner that doesn't tear the organization apart. And I think depending on the nature of the investigation, that's going to become increasingly challenging. There are various ethical requirements that I'm going to go through in just a second, but I think that this is really going to test the ability of a lot of people to work through these really serious problems that might come up. So the dynamic between the company and its employees is something that we're all aware of under the ethical rules. Obviously, when you work for an organization, your client is the organization and not necessarily its constituents, the board members, the CEO who hired you as in-house counsel, the CEO who hired you as outside counsel, who works with the organization day to day. But what Yates, essentially the result of Yates, is that you need to make sure that your clients understand who you represent and what the implications of that are, particularly when it comes to investigating allegations of misconduct. I think that now when you initiate an investigation internally, it's going to be all the more important that as you proceed, you're constantly thinking in your mind about whether or not your interests are diverging with those of the constituents of the organization. And I've over the last year as this has evolved, I'm hearing from counsel elsewhere increasingly that they're being asked to retain independent counsel for executives, board members, and employees when you're going to be conducting an investigation that seems like it might be significant. The other thing I want to point out is that you don't always know when you're starting down the path of an internal investigation how significant the findings are going to be, or really how far-reaching the conduct might be in terms of folks involved in the organization. And I think that is particularly challenging because you don't have a crystal ball. And so I think, again, as you proceed, very critical that you make the fact that you represent the organization clear to your organizational constituents and what that means. That's going to lead you right into the need to manage conflicts. And I think that's where my point that I just made in terms of that change in the dynamic is really going to become apparent. Because I think that it's terribly challenging to tell your boss, whether that be your internal boss or your client who is directing you, look, I actually don't represent you, I represent the organization, and here's what that means. And if you have worked closely with management, many general counsels actually wear a dual role. They're an executive as well as being the lawyer for the organization. And if you're an executive and you were involved in providing the advice that might relate to the conduct being investigated, I think you have to carefully evaluate very early on whether or not separate counsel is going to be needed. And I think in many cases it might be a very prudent decision to be cautious about this rather than wait until later. I have down here the ethical implications being competence and independence of counsel. I'm going to cover that in a second, but the gist of this is that the Department of Justice is really leveraging the potential wrongdoers in terms of getting their work done. And I think that's really no surprise to anyone who has been through a civil investigatory demand. The amount of time and expense to prepare the information for the government in terms of them evaluating their case is pretty daunting. But I think this issue of competence becomes even more important. Many attorneys know the company very well, but may or may not have deep regulatory expertise or deep expertise in white-collar prosecutions, and I think it's going to be really critical for general counsel and outside counsel to identify and recognize the need for someone who has the specific competence or multiple individuals to assist in investigations, so that when you go to the government and seek cooperation credit, you can show that you've done a very credible, thorough investigation. I think that one of the things I'm going to talk about in a minute, but the first thing that I thought in kind of preparing for you is what practical suggestions can I give to folks in terms of how do I process this and turn it into an action plan. And I think that while we walk through all of the points in your mind, I think you should be reviewing in your head what your investigation process is, if you have policies and procedures, and whether or not those might need to be revised or updated as a result of the Yates Memo and the really important implications for ensuring that you address conflicts and make sure that you have the appropriate level of independence to put forth a credible investigation to the government to get that cooperation credit. I have a short list of possible counsel for executives. I think you're going to see a lot more people asking for independent counsel early on. And I think also I have Upjohn templates. We'll talk about that. But in terms of representing an organization, you have an ethical duty to ensure that the constituents of that organization understand when their interests are going to be adverse to the organization, and particularly in the case of investigations, you want some items to be privileged. And in order for the privilege to stand, you need to make sure that employees, executives, and officers that you're interviewing understand that you represent not them, but the organization. And I think that one of the thoughts I had is that this conversation is most appropriately had well in advance of any significant internal investigation. I think it's a lot easier to discuss this in the abstract than it is when you're facing down the reality of a very serious allegation either internally raised, or if you have an external threat to the organization, either a relator under a False Claims Act or perhaps a DOJ investigation. I think that in terms of conflicts, I think this really boggles my mind a bit when I start to think through all the different levels of conflicts. I think being in-house counsel just got tremendously harder. And frankly, being outside primary counsel for someone is also complicated by this. Again, as outside counsel, because I know some of you on the phone are outside counsel, you're going to have to evaluate whether or not your relationship with the executives who hired you is such that you may have a conflict in terms of representing the organization. I do not believe that the ethical rules would prevent you from representing an organization simply because you are hired by the board or the CEO, but I just think a sensitivity to the real or perceived conflicts and the impact of that and the credibility of the investigation is critical. I also think that when you're going through one of these investigations with your clients who you've known for a very long time, they can be very disruptive to relationships within the organization and really challenging for a lawyer who has a very strong trust relationship with the people who brought them in, who may or may not be implicated in the conduct that you're investigating. So I just wanted to remind you that very important to be thinking about this early on to assess whether or not the interests of the constituents are likely to diverge, and frankly you need to inform people early on when you're interviewing people and doing your internal investigation that you are not their attorney, and I think you're going to see more and more people who are going to ask whether or not they can have their own independent counsel. I'm just citing to the ethical rules here. Again, we've covered this a little bit, but it's critically important that if you really want to get full credit for your internal investigation, that it is performed by someone who has a very deep knowledge of the subject matter area and understands all the ins and outs of what they're doing, as well as having counsel that is very experienced in dealing with the Department of Justice and in white-collar issues. I think it's going to take a village going forward rather than just an individual to, obviously depending on the size and scope of the investigation, but I think this is really going to be a wave of the future. I think also I note the Supreme Court Rule 2.1 regarding the lawyer as an advisor, and again I think that this is particularly relevant to in-house counsel where you wear a dual, multiple hats, but share a dual role, both being a business strategist and a member of the executive team making decisions about various initiatives that you're undergoing, as well as the lawyer for the organization. It's really interesting because in the last 5 years in particular, in-house counsel has increasingly been given an executive title. Now, whether or not they're actually functioning as an executive of the organization is not always dictated by the presence of that title, but I would tell you from the perspective of the government, I think that's something that they're going to be looking at in terms of how they see the investigation and who is being identified as being potentially involved in the conduct, which is what's required by Yates. Confidentiality, I raised this obviously critically essential to the attorney-client privilege, and Ryan's going to talk about that, but there are some important exceptions to the duty of confidentiality, particularly I practice a lot in Illinois as well, and their ethical rules are slightly different than Wisconsin. Wisconsin does have a mandatory duty to report out and up in the event of a situation where a client is going to or has committed a fraud or a crime that might involve bodily injury or death or there's a reference to significant financial harm to others. Now, I'm not suggesting that because of Yates we suddenly have a different mandatory duty of reporting up or out, but I will say that I think it's really important to ensure that executives understand fully now that the government has made it very clear that people who proceed into gray areas or really push the envelope are going to be held accountable for their actions. And so therefore I think it's important as lawyers that when we're counseling people we make sure that they understand that your advice and your ability to keep confidential what they're telling you does have some limits. I am going to turn it back over to Ryan to talk a little bit about investigations and things you should be thinking about, and then we'll come back and talk a little bit about my current to-do list for all of you based on all that we've talked about. Thanks, Ryan.
All right, so now that we've gone through the rules of professional conduct and you have your ethics credit, now we can talk about what do we do in these internal investigations now after Yates. I think one of the big sea changes, and I mentioned it before, is this sort of all or nothing approach to get cooperation credit. One of the biggest judgment calls and kind of one of the most difficult judgment calls in the course of conducting internal investigations is, where do you stop? At what point have you done enough? Have you looked at the issue? And inevitably there always come up other issues that either during an interview an employee might say, well, you're looking at this, have you looked at this other transaction? And this sort of mission creep problem is something you always have to deal with it. And I remember the first internal investigation that I worked on back as an associate involved this very issue. It started out with a allegation that an internet company was essentially booking round-trip transactions to boost their internet advertising numbers, which were what all the stock analysts were looking at, and this was at the height of the dot-com bubble. And we started looking at the one transaction, and then some employees said, well, did you know that we sold this other business, and I think this advertising component was part of that. And then there was another transaction, and each one sort of involved, they would reach a deal price in cash, and then they would go back to the buyer of the business unit or something and say, and can we give you, $30 million in internet advertising? And the buyer didn't really care because it was essentially free advertising, and they would book that as revenue. But this problem of dealing with sort of mission creep and how far do you go becomes a much more difficult call in the post-Yates world, because you have to disclose all facts and related to any corporate wrongdoing and individual involvement before you even get over that bar of getting cooperation credit. Now, Ms. Yates, in a speech last May, has tried to allay some of those concerns and said, companies don't need to boil the ocean or go down every road, that this is essentially what companies have been doing all the time. But at the same time, the stakes are much higher and the discretion with the government also much higher, such that you don't want to go down the road of an expensive investigation and then somehow end up at a disagreement with the government in terms of how far you had to go. So that's just a big impact of Yates, and something that counsel has to think about. And one way to deal with that is to be in close communication with the DOJ investigators or government investigators, so that you're sort of on the same page. And running these from an outside counsel perspective, that's one of the things you want to throughout the investigation, sort of be in contact with the government and kind of be in step with the lens through which they're viewing the case. So, as Heather explained, there's all these issues with conflicts and independent counsel and who runs the investigation, and so that continues to be a difficult problem to deal with. Can you run the investigation in-house in light of those ethical concerns that Heather highlighted and some of the practical concerns that I'm going to highlight as well. Another issue that I think is still developing is what impact does Yates have on corporate waivers of attorney-client privilege. Certainly the tone has shifted in terms of this all facts, all or nothing approach. And is the DOJ either implicitly or explicitly going to be asking for more fulsome waivers of the attorney-client privilege? Now that gets to the question of, does the privilege apply in the first place? And so I'll circle back to this decision of in-house or outside counsel and just talk about the privilege itself for a moment. It's an evidentiary concept and has developed through the rules of evidence. This 90503 is the Wisconsin statutory reference. The federal rules of evidence deal with it at Rule 501 and 502. And 502A of the federal rules is a relatively recent addition in 2011. And that deals specifically with potential selective waiver of privileged communications in a government proceeding. And it says essentially that waiver extends to other communications besides the specific communication that is waived in a government proceeding. Only if the waiver is intentional, it deals with the same subject matter, and ought in fairness to be considered. And so in combination with sort of the Yates approach of all facts and this relatively recent amendment to the federal rules of evidence, there is, and I've heard anecdotal evidence, indications that kind of privilege waiver is more of an open notion than perhaps it has been in the past, but kind of yet remains to be seen on that. The key elements of the attorney-client privilege. It must be, of course, a confidential communication between an attorney and a client for the purpose of obtaining or providing legal advice. And particularly important is that only the communication itself is protected, not the underlying facts. And so how this typically plays out is you may learn facts through interviews of the employees that are privileged, but the government has always and will continue to seek those facts post-Yates Memo. And so there's kind of this fine line between disclosing a privileged communication versus the underlying facts of those communications. Now Heather touched on the many hats that in-house counsel often wear, particularly now that they have executive titles, and more and more, particularly in organizations, larger organizations, in-house counsel and general counsel are part of the executive team. They are giving strategic advice. They are giving business risk advice based on the kind of compliance and legal environment in which the business operates. And these many different hats makes it a thornier issue in terms of whether a particular communication with in-house counsel or general counsel is privileged. In this case, from 2007, kind of sets forth a standard that courts will look at the primary purpose of each communication to be able to invoke the privilege, and that business advice unrelated to legal advice is not protected by the privilege, even though conveyed by an attorney to a client. And so that makes it more difficult to separate and establish that a particular communication with an in-house lawyer is privileged versus communication with outside counsel, where there's generally a presumption that communication between the corporate constituents and the in-house counsel with outside counsel, that those are privileged communications and will be deemed so absent a clear showing to the contrary. Whereas communications with in-house counsel, more so every day, are subject to more scrutiny with respect to the privilege, and generally must be justified and strategically asserted. Now there are ways, particularly in larger organizations, that in-house departments can deal with this by having sort of separate investigations counsel departments that sort of their sole task is to conduct internal investigations. But that's generally not practical with smaller organizations, and so you have this issue of will a court deem that there is a privilege that exists in the first place? And so this all, at the start of the investigation, gets at kind of the initial decision of who will conduct it. Will it be in-house or led by outside counsel? Of course, partnering with the in-house counsel, and it's really that partnership process that typically works the best on an investigation of any sort of importance and scale, because the in-house counsel has the experience, they know the players, they know the organization back and forth, and the outside counsel has the experience, the relationships generally with the government investigators, and has this benefit of that the privilege generally is not going to be challenged, and thus the organization can control the information that it desires to disclose better than if the privilege can be breached more easily on the front end. Yates, I think, probably pushes the direction more towards having outside counsel lead the charge on these types of investigations. You've got a much greater tension now that is set up between kind of the employees and the executives that are aware of Yates and the focus of the Department of Justice on individual wrongdoing. And so these judgments that must be made in the investigation in terms of requiring cooperation, one of the diciest judgments that you have to make in an internal investigation is, do you tell an employee that you have to sit down for an interview in the investigation or you're going to be fired? That's one decision that often comes up. So requiring cooperation, judgments about providing counsel to individuals and whether the corporation is going to pay for it. Given the closeness, as Heather highlighted, that in-house and general counsel work with these executives and the people that may be implicated in the wrongdoing, I think that favors or is going to trend towards looking at outside counsel, again, in light of all the circumstances, depending on what's at issue, what the scope of the wrongdoing is. Is it a bet the company type of issue or not? So a couple other things that have always been present in terms of first steps in an internal investigation, and that is preserving the facts, and that makes it all the more important in light of this all-or-nothing approach of Yates, is preserving those facts at the outset. So one of the first things you need to do is evaluate the need to take immediate steps to preserve evidence and avoid allegations of obstruction of justice. You don't want to end up like Arthur Andersen in the Enron situation where there was massive document destruction, and that in many ways can be worse than the underlying wrongdoing itself. And you want to suspend routine document destruction policies. And those two things can often be done in the background, either with the company's IT personnel, or oftentimes you'll need to retain an information technology expert to help you preserve that without alerting the potential wrongdoers that the investigation may be started. You may, as a strategic matter, not want the potential wrongdoers to know that the company is looking at this. And so on the front end, you have to kind of game out all these different things. And that's, in terms of the timing of issuing the document hold notice to relevant individuals, that's an assessment you have to make as well, because once that goes out, there are going to be hints of what the investigation is looking at. And so, in addition, you may need to do initial triage fact-finding first, where you have to just learn what the underlying facts are. And this is another judgment call in terms of, in those initial triage phases, whether you need to provide Upjohn warnings, or whether learning the basic facts of what occurred and who may have been involved, an Upjohn warning may not be necessary right away. Last, I'm going to touch on and then probably skim over the work product issues. Conducting interviews. This is where a lot of the implications of the Yates Memo come in, is when you're sitting down asking to conduct interviews with employees. It's at that stage where the employee is going to look to you and say, well, do I need an attorney? I've heard about all this Yates Memo. Am I the person that the company is going to serve up to the government as the sacrificial lamb, so to speak? It's at this point where the ethical issues become, and having those at the top of your head become particularly important, because you can't answer that question. You can't give that employee legal advice in terms of whether or not they need an attorney. Now, you may make a strategic decision that they do, and facilitate that process, but you can't tell that individual whether or not they need an attorney. And your hat of representing the corporation has to be on at that point. Is it in the corporation's best interest to learn what the corporation needs to know to deal with the allegations of wrongdoing? But aside from that point, you must make clear, you must provide the employee what has become known as the Upjohn warning. And I'll circle back to that. It's based on this case, Upjohn versus United States, which really is the seminal case kind of setting forth the corporate privilege, but also address this issue of what attorneys, it becomes the foundation for the Upjohn warning. Later on, an employee will say, I thought you were representing me. I thought you were my personal attorney, and therefore anything I said to the corporation's attorney during that interview should be suppressed as attorney-client privileged. And if that is the case, if you don't provide the Upjohn warning, one, that can be suppressed later on, and the corporation loses control of that waiver determination. And also, you may find yourself in an ethical violation. So I think different counsel have sort of their own styles in how they convey the Upjohn warning, how much detail they provide. But there are at least three things that you have to tell this employee. you have to clearly identify yourself as the attorney for the corporation and not the individual. That's key. I recommend you tell the employee that, therefore, we view this conversation as attorney-client privilege as to the corporation, not between you and me, and we ask that you keep it confidential in order so that the corporation can preserve that privilege. And then finally, telling that individual that it is the corporation's privilege and that the corporation will decide whether or not to subsequently waive that privilege and disclose it to other third parties, including potentially the government. Those basics have to be conveyed in order so that the person you're talking to realizes that you're not that person's lawyer, that it's the corporation's privilege, and the corporation may waive that privilege and disclose the information that is learned subsequently to third parties. So with that, in the materials there's also information on the work product doctrine and steps that in the course of the investigation that counsel can take to preserve that work product doctrine. That's not affected as much by the Yates Memo, and so I decided to focus on these privilege and Upjohn Warning issues, and with that I'm going to turn it back over to Heather to give her sage advice on what you should be thinking about kind of preemptively in light of Yates.
Thanks, Ryan. Let's see here. All right, post-Yates, what can you do? I think that I'm going to walk through just some high-level points. I think there's a lot that you could do to be ready. I know that there are a lot of to-dos on everyone's list, but this is something where I think a little bit of preparation can go a long way. I think that it's critically important, as I mentioned before, that you educate your board, your executive, your management teams, and what are you educating them on? You're educating them on the critical importance of ensuring that your organization has a meaningful compliance program in place. That's really, I think, what the message is here, and that really is the essence of getting cooperation credit. That's where the federal sentencing guidelines started out. And so if I'm advising the board, and when I advise boards, and people are saying, oh my goodness, this focus on individual accountability, what can one person do? I'm just a director. And in the case of not-for-profit organizations, which are a lot of the health systems I represent, many of them are volunteers. And so I think that what I would be counseling my clients to do is to really understand whether or not your organization has a meaningful compliance plan. And by that I mean, does your board, your executives, do they really have a clear understanding of the risks that they're facing and the adequacies of the organization's current controls in place? That is at the heart of compliance, what you've got. Do you have a way to detect problems early? Do you have a way to prevent them because of training you've done, policies you've put in place, checks and balances in the system? And I think that too often the board and executives hear very high-level reports on things that they need to pay attention to. And I think anymore in this day and age, it's really critically important that in executing their fiduciary duties, each director really does have their finger on the pulse and have a working understanding of the key risks, what controls are in place, and then the next and most critical step is that there is some process in place to evaluate the effectiveness of those, and that there's some empirical information heading back up to the board. I'm speaking after this actually on cybersecurity, and I can tell you that's an area where you have a very concrete example of the importance of boards understanding exactly where they stand. I will tell you many directors with whom I've spoken on compliance issues have a very low level of risk tolerance when you speak with them, but when you actually evaluate the resources that they have dedicated to their compliance program, there's a tremendous gap there. And so what I would say to executives and board members is you need to put your money where your mouth is, and if you have a low risk tolerance, then you need to make sure that you have checks and balances in place and that you're receiving information about the adequacy of how those have been implemented and whether or not they've been effective, not simply lip service to our commitment to our code of conduct. While that is important, and I think culture plays a big role in all of this, and that's when you hear the prosecutors speak at conferences, and I've been to numerous national conferences since the Yates Memo came out, and I will tell you, they say, look guys, we know when we see the compliance plan and talk to people very quickly whether or not it's really legit and whether or not the resources really have been dedicated. That doesn't mean that that's that you have to have you turn the world upside down in terms of what you're doing, but it is important that you've done an analysis of what you think your top risks are and that you feel that you have those gaps covered and that you're receiving information in terms of dashboards and reports to understand how those controls are being put into play and whether or not they're effective. The second thing I would say is that you really need to educate your compliance team as lawyers. I think that there has been an increasing level of back and forth between compliance officers and general counsel in terms of who really has the duty to manage the risk of the organization, and that's a separate presentation in and of itself. But I will tell you, I've seen too often in the turf wars that can take place the compliance team launching into something that they never believed would result in very much. They thought it would be a low-level investigation, and lo and behold, I have all of this investigatory material. Interviews have been conducted. There's been emails back and forth. And I think it's really important to spend some time on explaining to the compliance team when it is necessary to call counsel. And that doesn't mean that every investigation has to be done under privilege. It just means you have to ask the question and make sure that there's an open line of communication and coordination between counsel and compliance to make sure that you're not missing an opportunity to protect your client, the organization. I think that you need to review and possibly update your internal investigation procedures and policies. You may have some, you may not, but I think that it is very, very challenging. When I speak about data privacy and security and we talk about data breaches, I can't tell you how hard it is to come up with the game plan when you're in the middle of the play. It is really tough, and this is one where I would suggest people take a little bit of time to poke through what they have in place and what they want to do when an issue comes up so that you're not figuring it out while you're going through it. Much easier to have some principles in place in advance. What might those look like? Ryan talked about having some kind of a process for the Upjohn Warning. Do you have a script that your attorneys have to use that's consistent? Do you have a written summary of that you would provide to the employee? Have you educated people about this in advance so that when they hear about it, it's like, oh yeah, I know about that, versus, oh my goodness, you're telling me that you might turn me into the government. Do I need a lawyer? And I will tell you, having given the Upjohn Warning numerous times, that is the question that many people ask, and it may not just be your executive, it could be your, boots on the ground employee who starts to ask that question. Really important that you have a ready answer prepared and that you are not thinking it through while you're doing it. I think that obviously you can decide whether or not the circumstances dictate a written acknowledgement from the employee that you've given the warning. I think you need to be prepared for people who say, you know what, I want to stop, I want a lawyer. I want you to hire me a lawyer. And I think that goes to the next big section I think you need to think about in your procedure is under what circumstances will you retain independent counsel? When does the organization pay for that? How are they going to coordinate with outside counsel? And whether or not you have sort of a short list of your panel and whether that panel is covered by your insurance. So there's several moving parts that you need to be thinking about in advance so that you're not caught unawares. I think that planning for when you will go to independent counsel, not just use in-house counsel, is another issue where you want to have given it some thought. you may have certain categories of issues that you've decided in advance. I think many general counsel are under tremendous budgetary pressure. They are often viewed as a cost center, and they certainly don't want to increase costs to the organization. This is one where I think some foresight and planning in terms of getting the buy-in of executives and the board, these are circumstances where the organization is best protected by the allocation of resources to do this right. And I think having that conversation in advance and just understanding what the range of resources that you can count on is really, really important. I think that in terms of how you do an investigation and think about your procedures, it's important to remember Yates requires that you turn over the facts, right? That doesn't mean that this has suddenly changed the attorney-client privilege, but I think being mindful of how you're going to collect facts in a way that is going to be meaningful. Too often, you often have people who write very unhelpful emails. Again, I'll give the privacy example just because it's on my mind right now, but very often I'll have emails going back and forth that get forwarded to me where 12 people have said, we have a breach on our hands. Well, a breach is actually a legal term of art that requires a legal analysis. It isn't, you might have data that has been accessed impermissibly. That doesn't mean you have a breach. And so this goes back to me to some of the training that you could do up front with your team to make sure that they're using email for factual communications, and when something doesn't seem right, they pick up the phone. Particularly important. How you're going to document your internal investigation, again, very critical to what you're going to provide to the government and giving thought to what's going to be privileged and what is more factual in nature. Obviously, interviewing is an art in and of itself. I think I would be mindful in my procedures about who can conduct employee interviews, who needs to be present, and what the process is going to be for doing that. I want to jump because we're running out of time, and I apologize. This could be a separate session. Really important that you evaluate the adequacy of your D&O coverage. And I think that this is more important than ever with the Yates Memo. You need to assess the scope of your coverage. Who is covered? Is it only officers and directors, or does it cover other management employees, other employees involved in highly regulated activities? So for a health system, it could be a billing department. For an international company, it could be your sales department. So very important that you figure out who's covered and when. Understand when it's going to be triggered. Oftentimes these policies are only triggered when the lawsuit has been filed or when there's been a final adjudication. You want to know if you have first dollar coverage, if you have coverage for investigations, if you have coverage for civil investigatory demands, should you receive one. Those are not automatic, and it's really important you understand what the exclusions are and when it's going to come into play. I think that investigation coverage, I mentioned it already, but really, really critical because I think that really digging deep into what that's going to include. Is it going to include independent counsel for the executives who may be involved? Is it going to include other consultants? What about reputational protections? If you hire a crisis management firm or a PR firm, is that going to be covered? Really important to consider that. I think too often people look for what is affordable, and I think it's important that you understand you get what you pay for often in this world, and so the experience of your carrier in actually dealing with claims of this nature is really important. If you're operating in a highly regulated industry, you're an international business, you need to make sure that the policy that you purchase and the carrier you're working with actually has experience in dealing with really significant regulatory investigations. And again, the ability to select counsel, always an issue. I think it's really important to know whether or not your go-to outside counsel is part of the panel that can work with you. And if not, I'd make the case in advance as to why you want them on that panel if you should have an issue. I think the familiarity they may have with your business, your organization, and the trust that they've already engendered in your executives can be absolutely priceless when you're going through a crisis of this nature. And it's really important you consider that in advance. It's very hard to make the case after the fact. And I am sorry to rush at the end, but I think we have, what, a minute left here? I want to open it up. 2 minutes. Oh, great. Well, does anyone here have any questions? No. All right. One question I often get with the focus on individual accountability is whether or not Yates applies to all employees or just high-level employees, executives and officers. And the memo itself is very clear that it applies to all within the organization, not simply those who have decision-making authority. And it includes a look at both people who are involved with and responsible for conduct, so decision makers as well as those people who are carrying it out. And as Ryan mentioned, it's without it's without a focus on their ability to pay, which historically has been really a true focus. There's been two really big settlements recently that just in September, the CEO of Toomey Healthcare System was levied a fine of $1 million personally, and he was also denied the indemnity that his organization gave him, so he has to make reparations for all his defense costs that were paid as part of his settlement, as well as being excluded. So that's an example. Another example was two executives with North America Healthcare entered into a settlement. One was the vice president of reimbursement evaluation, and she was levied a fine of $500,000 personally, and also precluded from having the organization pay that fine. So things that you ought to keep in mind. Any more questions that have come in, Nancy? Are we at time? Thank you very much for attending today. You have our contact information. If you have questions or something comes to mind after the fact, please don't hesitate to email Ryan or I. Thank you for joining us this morning. We really appreciate your time.